I swear sometimes I get myself like when I do videos and I provide information and it's just be crazy how sometimes it can turn into something completely we gonna talk about it, okay? Welcome to my page, y'all. Welcome, 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 welcome. My name is Tammy Arrington. I am the owner of Tammy A1 Consulting, and we are going to talk about borrowed defense. I did a video, first and foremost, let me do my disclaimer. The information that I'm going to provide to you today does not constitute any financial personal, or legal advice. I am going to show you the information directly from the source, and you take that information and you do with it what you will, okay? All right, but I want you guys to hear me and hear me clear. I did a video about borrower's defense, and in that video, because of federal student loan borrowers who are dealing with defaulted student loans, there are provisions in the borrower's defense application that allows if you are a borrower who is in default to get your loans out of a default status based on the application that you have submitted for borrower's defense, okay? But I want to talk more, and in the video that I did, I even explained this. We do not want to be putting in a borrower's defense application if you do not have a valid claim. There's a lot of information, a lot of misinformation that is circling through the internet when it comes to the list of schools, that 100 plus schools that is connected to the Sweet versus Cardona. Well, now it is the Sweet versus McMahon settlement. That settlement has closed, which means that even if you attended one of the schools that is on that long list, you are not privy to any of the clauses of the settlement. What that does mean for you is that you have attended a school that is on a list, and if there is an application that you need to submit that you have a claim for, that you qualify for, under borrower's defense, that means that there is some evidence out there to help support you with your claim. That means that we have attended a school that has a history of defrauding their borrowers or misleading their borrowers, whatever the case may be. That's what it means for you. There's supporting documentation out there to help you with your claim. But when you are submitting a borrower's defense application, you are submitting this application under the penalty of perjury. The borrower's defense application is not an overnight process. We have borrowers who are still waiting on decisions on their borrower's defense application. The video that I made that spoke about you getting your loans out of default, I made sure that I said in that you want to go through other channels to get your loans out of default, which means one could be rehabilitating the loan. Not only that, if there's a consolidation that you want to seek, or if you need to go into a consolidation. But some borrowers have already consolidated, and once you've already consolidated, you can't reconsolidate the loan into itself. There would have to be another loan or an outstanding loan that you have that you can consolidate into that loan. And I hope that makes sense. I don't want to go too much more. Go back a few videos, you'll be able to see it. But it's important to know all of your options if you are dealing with a defaulted student loan, all of the options that are available to you before you make a decision. And one of the things that is the most bothersome, because majority of borrowers currently who are dealing with default, they were already in default prior to COVID-19. And what's unfortunate about that is during COVID-19, with the deferment of federal student loans, with that huge pause that lasted for well over 3 years, a lot of borrowers and there was a lot that was going on. We were dealing with a national crisis. A lot of people couldn't even think about student loans. They were trying to stay alive. But when it comes to that time frame that happened, a lot of borrowers, and I wish that the Department of Education would have made aware that if you would have went into a rehabilitation program went into rehabilitation during that time, if you were a defaulted federal student loan borrower, you could have went into rehabilitation and not paid a thing throughout that process. And we could have probably had a lot of borrowers who are not even in default. But that time has passed. Even with Fresh Start, they offer Fresh Start. But even with that, there was a lot of things that were going on with the Department of Education. So it's just unfortunate that we have borrowers who are in default right now and currently dealing with the effects of that. I have a video as well going back where I speak about the credit reporting aspect of defaulted student loans and what things and records you need to request if you're dealing with a defaulted federal student loan. So what you see up here is that you have the right to request your student loan records. And I actually created a guide that is available on my website that will help you with requesting your documentation for your records with all the different agencies that have this information on file. Not only requesting your credit reports, but requesting information from the Department of Education, and also other agencies. When it comes to borrower's defense and you're dealing with a school that has claims against them from other student loan borrowers, you want to get that information as well. And you have the right to get that information from these agencies that has information on schools and their conduct. Because mind you, the Department of Education is in contract with not only these loan servicers, but there's things as well. These schools are receiving funds from the federal government, so there are laws and there are rules and there's regulations and things that they have and processes and procedures that they have to follow when they are receiving these funds. But let's talk about it. I just wanted to clear that up because when it comes to you and your borrower's defense application and utilizing the borrower's defense application to get your loans out of default, I want to make sure that you are putting yourself in the best position possible and not just relying on the borrower's defense application. Because even if you put in a borrower's defense application, you are still sitting in a, oh, I'm sorry, that's me and my daughter here. Let me get this over here. Even if you are in a have your application in for borrower's defense, the application or the loans are just sitting there. You're still going to accrue interest. And then not only that, there's still a process that needs to happen because if the application isn't approved, then you're still dealing with this loan that has now collected even more interest when you could have went through a rehabilitation program if you qualify. And then not only that, if you consolidate, you want to think about prior to doing a consolidation, what actually take place. Now, on the student aid website, you can go and look at all the information that talks about if you are dealing with a defaulted loan. This right here gives me, don't get discouraged if you're in default, like, wait, what? I'm extremely discouraged, but it tells you about the defaulted student loans, what happens when you rehabilitate the loan. When you're going into rehabilitation, you should not be in a rehabilitation program for longer than 9 months, okay? Now, it tells you here you're going to make all 9 payments during a period of 10 consecutive months. No longer than that time frame. And there is a lot of scamming that is going on out here. And listen, if anyone reaches out to you and they're talking about rehabilitating your loans for longer than that period of time, absolutely hang up. Okay. You should not be in a rehabilitation program any longer than this time frame. Okay. But one thing about when you go into rehabilitation, and we're going to talk about the consolidation part as well, the defaulted information is removed from the credit report. So if you are dealing with a defaulted federal student loan, then of course it's going to be reported to the credit report. But once you complete the rehabilitation process, that information is removed. Now, when you go through a consolidation, first and foremost, you want to make sure that you're weighing out all of your options with this because when you consolidate the loans, you can't unconsolidate the loan, okay? And like I said in the beginning, if you've already consolidated, then this may not even be an option for you if there's not a loan out there to consolidate into the loans that you are trying to consolidate, okay? So what that means for you, you have to be sure too, prior to consolidating your loan, is that what do you stand to lose when it comes to payments that you have already made? Because when it comes to your federal student loans, you're doing one or two things with these loans. You are paying enough to get your loans discharged under an income-driven repayment plan, or you're paying enough on the loans or you're paying towards the loans to pay them off in its entirety. And if you have made payments, and depending on what type of income-driven repayment plan that you may qualify for, once you consolidate the loans, then you lose that progress. And they are now doing things on some type of weighted average. There's a calculation for that. But if you consolidate the loans, then you have to know what you stand to lose when you do that consolidation. And I know if you're in default, it's a tough place to be in within itself because there's a decision that has to be made. But with anything, you want to make sure that you do it with your best interest, at the forefront. Not only that, there's also, if you're dealing with a financial hardship, there's other defenses that you can raise as well when you're in a default. If you're dealing with a financial hardship and you can provide that information to the Department of Education that you're dealing with a hardship, then you want to be able, to make sure that you provide that information. But also we have to remember too, when you're dealing with a debt collector, because that's what happens when you go into a default and you're dealing with a debt collector now, they are subjected to laws as well. They're subjected to um, um, the FDCPA. Not only that, the information that's on the credit report, all of that information still has to be accurate. There are still processes and procedures that still are in place when you are even in default, even though it may not feel like it, that these that the department or that the debt collectors have to follow procedures, but they do. They can't just violate your rights in the process of collecting on this debt. And you have the right to know what you are paying for, even if the loan is in a defaulted status. You want to request those records. Like I said, you have the right to request that information from the Department of Education. You have the right to request that information from the servicers of the loans. Not only that, from that debt collector that is now collecting on this defaulted student loan. So you're not just at the mercy of of the Department of Education or at at the mercy of the debt collector. But I want to show you too on the borrower's defense application, if this is an angle that you are going to go to utilize to get the loans out of default. But I want you to only submit this application if you actually qualify for borrower's defense, if you actually have a valid claim, because we're submitting this under the penalty of perjury. So we don't want to lie. And first and foremost, when it comes to the borrower's defense application, there is no reason to lie. There is plenty of proof out here where these schools who have been receiving these funds, these Title IV funds, have been negligent in their practices, okay? But you want to understand the application and what you're actually submitting. And down here is where I made the video as far as what you're able to do when it comes to if you're in default. Right here at the bottom here on page 19, it speaks about let's see. Okay, where was it at? Okay, it tells you about forbearance and stop collections here. Okay, page 18. You have the option to request forbearance or stop collection status. Let me make this a little bit bigger. Okay. If you're not currently in default of any federal student loans, your loans will be put into a forbearance status while your application is under review. Forbearance means that you do not have to make loan payments and your loans will not go into default while your application for a borrower's defense discharge is pending with the Department of Education. Your servicer will notify you when your loans have been placed into forbearance status. So this is speaking to a borrower who is not in default, okay? Because even a borrower who's not in default, who puts in a borrower's defense application, they have the option to put their loans into a forbearance while a decision has been made. If any of your federal student loans are in default, your loans will be put into a stop collection status while your application is under review. Stop collection status means that the holder of your defaulted student loan will not attempt to collect on the defaulted loans, including efforts to withhold money from your wages or federal income tax refunds while your borrower's defense application is pending with the Department of Education. So this was the video that I had spoke about to defaulted student loan borrowers, that they have the option, if they put in a borrower's defense application, to put their loans in a stop collection status, that the loans can go into that. So if you are a borrower who is in default and you believe that you qualify for borrower defense to repayment and you put in an application, you have the ability to put those loans into a stop collection status. I wish to have my loans placed into forbearance or stop collection status by selecting that there, okay? All right, but like I said, we're submitting this under penalty of perjury. It tells you if you make a false statement or misrepresentation on this form or any accompanying document, it is subject to penalties that may include fines, imprisonment, or both, and it's not worth it, okay? So make sure that you are going over all of your options prior to choosing a borrower's defense. If you do have a claim or you're not unsure, I do offer one-on-one consults for borrower's defense that I can assist you with. Not only that, all your free information about borrower's defense is directly on the student aid website. They tell you right here to learn how to submit the strongest application possible, okay? So you're able to get all the information that you need about borrower's defense prior to you submitting the information, everything that you need to know, okay? So you go back to the student aid website and read that information there. All right, y'all, I hope that that helps, okay? But like I said, make sure that if you're putting in a borrower's defense application, we're not committing any perjury in the process of trying to get out of default. All right, y'all, good luck with everything.